Welcome to the Deep Dive. Today, we're tackling a case that honestly feels ripped straight from a legal drama script. It's got everything, family dynamics, serious allegations years later, a conviction overturned, then put back, all turning on how a jury was told to think about someone's emotional state.
Yeah, it's absolutely fascinating. It pits the messy reality of human trauma and memory against the very structured world of the law. We're talking about the King v. Ryan Churchill, a pseudonym, of course. And the whole thing pivots on this question. How should evidence of distress, especially when it's delayed, be explained to a jury in a sexual offense trial?
Right, and specifically, does modern legislation, the actual laws passed by Parliament, mean judges have to give these really specific warnings about that kind of evidence, warnings developed under older case law?
Yeah.
Or does the new law basically say, no, trust the jury to figure out how much weight to give it?
Exactly. That's the legal battleground. So our mission today is to unpack this whole story. We'll start at the beginning with the people involved in the allegations, follow the case up through the courts, county court, court of appeal, high court, hear the different arguments, and see how Australia's top court ultimately resolved it.
And we're drawing directly from the court judgments, the legal filings, so you get the real arguments, the real reasoning. It's a deep dive, all right, into a critical point of evidence law, but told through a really compelling human story.
Think of it as your guide to understanding how the justice system wrestles with these incredibly difficult human issues using the framework of the law.
Okay, let's set the scene. Where does this story begin?
It starts, like many of these cases unfortunately do, within a family setting. We have Ryan Churchill again, that's the pseudonym used in court, who began a de facto relationship with a woman named Rachel Russo back in 2003 in Victoria. And sometime after that relationship began, Rachel and her 3 daughters, one of whom becomes the complainant in this case, moved into Churchill's house. This creates that blended family context.
Got it. And the alleged offenses themselves, when did they supposedly happen?
The charges relate to events in 2005. At that time, the complainant, Rachel Russo's daughter and Churchill's stepdaughter, was just 13 or 14 years old.
So a very vulnerable age. Who are the key players we need to keep in mind as we go through this?
Well, first, obviously, Ryan Churchill, the accused. He was in his mid to late 30s, around 2005. The sources, they focus on his role in the allegations, the person in authority in the house, the alleged perpetrator.
And the complainant.
Yes, the complainant. Churchill's stepdaughter. She's the central witness, the alleged victim. Is her testimony about the events of 2005, and crucially, her state of distress years later that drives the whole legal saga. It's also relevant, legally speaking, that later on she received diagnoses of autism and other mental health conditions. This context becomes important when interpreting her behavior and testimony about the distress.
Right, that context sounds crucial. And the source mentions she's referred to as Isla Murphy later on.
That's right. In the epilogue section of the source material, discussing the high court outcome from her perspective, they use the pseudonym Isla Murphy. We'll stick to the complainant mostly, but just so you know, that name is also associated with her in the documents.
Okay. And her mother?
Rachel Russo, the complainant's mother, Churchill's former partner. She's absolutely pivotal because the key delayed distress disclosure we keep mentioning, it was made to her. So she becomes a critical witness at the trial, describing her daughter's state during that moment.
And then there are the judges who navigated this legal maze.
Yeah, you got the different levels. At the county court trial, it was Judge O'Connell. Then, when Churchill appealed to the Victorian Court of Appeal, the VSCA, the judges were Beach, Taylor, and or JJA. And finally, at the very top, the High Court of Australia, the bench was Chief Justice Gagler and Justices Gordon, Gleeson, Jago, and Beach-Jones. Their different interpretations of the law really shaped how this case unfolded.
Okay, let's get into the specific allegations from 2005. There were 2 charges of incest, right?
Correct. The first charge relates to an incident alleged to have happened late in Rachel Russo's pregnancy. The complainant testified that Churchill came into her bedroom when she was in bed. He sat down and, according to her evidence, said some really unsettling things.
What?
She testified, he said, and this is from the source material recounting her evidence, "Out of your sisters, I like you the most," and called her an attractive girl. She said she told him she wanted to sleep, but he allegedly got upset, pulled down her bedclothes and her pajamas.
Oh, wow.
Then she testified he got on top of her and penetrated her vagina with his penis for about 2 to 3 minutes, ejaculating outside her body. She also gave evidence that she experienced pain and saw bleeding the next morning. Those alleged words, "Out of your sisters, I like you the most." They really paint a picture of grooming, don't they? Singling her out.
It's a deeply disturbing account. And the second charge,
This allegedly occurred around October 15th, 2005. So, a bit later. Rachel Russo was actually in the hospital at the time, having just given birth. The complainant and her sisters were at home with Churchill.
So the mother was absent.
Exactly. The complainant testified about two things from this period. First, she said Churchill watched her while she was in the shower. When she told him to get out, his alleged response was just, "I own the house." A real assertion of power, you know.
Yeah, absolutely chilling.
Then later that same evening, she alleged he came into her bedroom again while she was in bed, lay on top of her, and penetrated her for several minutes. She also testified she was in pain during this alleged incident as well. The timing with the mother away and vulnerable, it adds another layer to the alleged predatory nature.
And did she testify about any threats? Anything to keep her quiet?
Yes, she did. She gave evidence that Churchill specifically warned her not to tell anyone. She claimed he threatened to go after her sisters if she spoke out, and also told her that her mother wouldn't believe her anyway.
Classic manipulation tactics, suggesting no one would believe her.
Absolutely. Creating that fear and isolation. Now, it's important to add a nuance here from the sentencing stage. The trial judge, Judge O'Connell, when he was deciding the sentence after the guilty verdict, stated he wasn't satisfied beyond reasonable doubt that those specific threats were made in that precise way for the purpose of sentencing.
Okay, so he didn't rely on them for sentencing.
Right. But crucially, he also said this finding was by no means inconsistent with the jury's verdict. So the jury could still have accepted the core allegations of sexual abuse when finding Churchill guilty, even if the judge had some doubt about the exact nature or proof of the threats for sentencing purposes. It shows that slight difference between the jury deciding guilt on the main charges and the judge weighing specific aggravating factors for sentence.
Okay, that makes sense. So the alleged abuse occurred in 2005, but the event that really became the focus of the legal appeals happened much later.
Exactly. This is the pivotal moment we keep coming back to. It happened about 12 months after the alleged offending, so late 2006 or early 2007. And it wasn't some calm, considered disclosure. It happened during a moment of intense crisis at the Children's Court. The context leading up to it was already pretty fraught. The complainant had run away from home the night before. She had apparently used heavy amounts of alcohol and marijuana. The police found her, and then she was at court with her mother, Rachel Russo.
So a really high-stress situation already?
Extremely. And it's in this environment that the disclosure occurs. Rachel Russo, the mother, testified about what she saw. She described her daughter as being very upset, very, very distressed. She said she was having a meltdown, was yelling.
Yelling what?
According to Mrs. Russo's testimony, her daughter was yelling that it was her mother's fault for bringing Churchill into their lives. And then, amidst all this turmoil, she blurted out that Churchill had raped her. Under cross-examination at the trial, Mrs. Russo apparently described the behavior even more starkly as erratic, violent, and psychotic, clearly a moment of extreme emotional overflow.
Wow. And what did the complainant herself say about this event when she gave her evidence later?
Her testimony, given years later in those recorded sections, added really important context. She said she didn't initially remember the exact conversation clearly, attributing it to how pretty traumatic the whole event was, plus the substance used the night before. But she did remember running away from home right before that, specifically because being in the family home was triggering reminders of the alleged abuse. But here's the absolutely critical part for the legal arguments. It's how she explained making disclosures generally. She testified, and this is pretty much a direct quote, relating the sources that she only ever told people about the alleged rape in the midst of meltdowns. Why? Because when she was calm, she said, it couldn't come out.
That's incredibly powerful. It speaks volumes about how trauma can manifest, how it can silence someone until a breaking point.
It really does. And she elaborated on these meltdowns. She connected them to her later autism diagnosis, explaining that she used to call them psychotic episodes, but now understood them differently. She described them as happening when she felt extremely overwhelmed and there's too much stimulus and it all happens and explodes. She directly linked these explosions to dealing with a lot in my head about her past and wanting to avoid things that triggered memories of the alleged abuse.
So her own explanation framed these meltdowns not just as general distress, but as a specific overwhelming response tied to her trauma and neurotype, and that they were, in fact, the only way she could verbalize the alleged abuse.
Precisely. And this is where the legal system has to try and interpret this incredibly complex human event. The prosecution's argument at trial was essentially, look at this profound distress, this meltdown where she discloses the rape. It's indicative of the trauma of having been sexually penetrated by the accused. They're saying the meltdown is the delayed trauma surfacing.
But the defense saw it differently.
Completely differently. They argued, hang on, look at everything else going on at that moment a full year later. She'd run away, used drugs and alcohol, she's dealing with police, child protection, she's at court, plus she has her own underlying psychological difficulties, the autism context. They argued the meltdown was no doubt the product of a whole host of difficulties. Well, the rape allegation was maybe part of that explosion, but you couldn't possibly say it was the sole or even primary cause of that specific meltdown 12 months down the track.
So the huge legal question becomes, can the jury be sure why she was distressed? Can they confidently link that specific 2006-2007 meltdown back to the alleged 2005 sexual offending, given the time gap and all those other potential stressors?
That's the nub of it, that ambiguity, that question of causation and how you interpret delayed, complex trauma reactions. That's what fuels the entire legal battle through the appeal court. How does the law handle something so messy?
Okay, that sets the stage perfectly for the first legal chapter.
Yeah.
County court trial.
Right. So the trial itself was held in the County Court of Victoria in September 2022. Judge O'Connell was presiding.
And the evidence presented?
Well, as we discussed, the complainant was the only direct witness to the alleged acts. So her evidence was absolutely crucial for the Crown. It was presented to the jury through recordings her VAR from 2018 and a special hearing from 2021. The prosecution, they also called her mother, Rachel Russo, her sisters, and they put into evidence the police interview with Ryan Churchill.
And Churchill himself.
He exercised his right to silence. He didn't give evidence, and the defense didn't call any other witnesses.
So with no other eyewitnesses, that evidence of the complainant's distress at the children's court, even though it was a year later, becomes really important indirect evidence for the prosecution, doesn't it?
Hugely important. It became a key piece of circumstantial evidence. The prosecution's argument was essentially her level of distress, the meltdown, the disclosure within it, that supports her claim that the sexual offenses actually happened. It's evidence, they argued, of the trauma she suffered.
So how did Judge O'Connell instruct the jury about this specific piece of evidence, this distress evidence?
Well, first he gave them the standard directions about direct versus indirect or circumstantial evidence. You know, the classic example, seeing someone come inside with a wet raincoat and dripping umbrella is indirect evidence that it's raining outside.
Right.
He explained that indirect evidence isn't necessarily weaker than direct evidence. He said something like, it makes no difference whether evidence is direct or indirect. It can be just as strong or even stronger. What matters is how strong or weak the particular evidence is. Basically, judge the evidence on its own merits, not its label. Then, he specifically used the complainant's distress as an example in this trial. He reminded the jury of the prosecutor's argument that the distress was indicative of the trauma of having been sexually penetrated by the accused.
Okay, so he put the prosecution's view clearly.
Yes, but he immediately balanced it with the defense's argument. He reminded them the defense contended the meltdown was the product of a whole host of difficulties: running away, substances, police, DHS, her psychological state, everything we discussed. He laid out both interpretations side by side.
Did he give any warnings about using this kind of evidence?
He did give a general caution about drawing conclusions from indirect evidence. He told them words to the effect of, you must take care when drawing conclusions from indirect evidence of that kind. He stressed they should consider all the evidence and only draw reasonable conclusions. And he reminded them they could only convict if guilt was the only reasonable conclusion from all the evidence, direct and indirect. He also gave a specific warning about the mother's, Rachel Russo's, evidence about the complaint. He told the jury not to treat her account as independent proof of the events, saying it shouldn't be treated as if it somehow independently confirms what occurred. It was evidence that the complaint was made in that way, not proof the complaint was true. And on top of that, he gave a general caution warning about the complainant's evidence overall.
It sounds like he covered the bases, presenting both sides' interpretations and giving standard cautions. Who were the lawyers running these arguments at the trial?
Okay, so based on who appeared in the later appeals, which usually lists the trial counsel too, for the Crown of the King, it was Mrs. Clancy, likely instructed by Mrs. A. Hogan from the Office of Public Prosecutions, the OPP.
And for Ryan Churchill?
His defense team was led by Mrs. R. Shan, SC, that senior counsel, with Miss H. Canham as her junior counsel. They were instructed by Dude plus George defense lawyers.
Right, so the jury heard all this evidence, heard these directions. What did they decide?
On September 12, 2022, the jury found Ryan Churchill guilty on both charges of incest.
Guilty. And the sentence?
Sentencing happened later, on March 7, 2023. Judge O'Connell imposed a total sentence of 8 years and 6 months imprisonment and set a non-parole period of 5 years. In his remarks, he specifically acknowledged the devastating effect the offending had on the complainant, noting how it aggravated her existing vulnerabilities.
But a guilty verdict and a sentence wasn't the end of the road here. Churchill appealed.
That's right. He sought leave to appeal his conviction to the Victorian Court of Appeal, the VSCA.
And the legal teams for the appeal.
They stayed the same at this stage. For Churchill, the applicant, it was still Ms. R. Shan SC leading Ms. H. Canham, instructed by Duke and George. For the king, the respondent, it was Ms. S. Clancy, instructed by Ms. A. Hogan at the OPP.
What was the main argument on appeal? What did they say went wrong at the trial?
The absolute core of the appeal was ground one. It argued essentially that the trial went wrong because of how the prosecution used the complainant's distress evidence, and critically because of the judge's directions or lack of specific directions about it.
So focusing squarely on that distress evidence again.
Exactly. There were other grounds mentioned, something about misconduct evidence and affectionate touching, but the Court of Appeal dismissed those relatively quickly, seeing them as related to decisions made by the trial lawyers, what they call forensic choices. The real fight was about the distress directions.
Okay, so the VSCA panel, Justices Beach, Taylor, and Orr, how did they respond to this argument about the distress directions?
They agreed with it. They found that ground one was made out, that the trial judge's directions were insufficient, and that this amounted to a miscarriage of justice.
Wow, so they overturned the conviction based on that. What was their specific reasoning? What did they think Judge O'Connell should have said?
Their reasoning was heavily based on a line of their own recent decisions, cases like Paul, Sekhol, and Namely. In those cases, the Victorian Court of Appeal had developed a rule, or at least a very strong guidance, about what judges must tell juries when distress evidence is used like this.
Okay, what was the rule?
It had two parts. First, they said the judge has to direct the jury that they can only use the distress evidence to support the idea that the offense happened if they are satisfied. There's a causal link between the alleged offense and that specific distress.
So they have to find the offense caused the distress.
Right. And second, the judge must also warn the jury that this kind of evidence generally carries little weight.
Little weight. That's quite a strong warning.
It is. And the VSCA found Judge O'Connell's directions lacking because he didn't explicitly tell the jury they had to find that causal link, and he didn't give that warning about the evidence generally carrying little weight.
Did the appeal judges make their own assessment of the evidence here?
They did. They specifically noted that, in their view, the causal link in this case seemed weak. They pointed to the year-long delay between the alleged offenses and the meltdown and all those other potential stressors present at the children's court running away, substances, court pressure, etc., basically echoing the defense arguments from the trial.
And they also mentioned how the official guidance for judges, the charge book, had changed.
Yeah, that was an interesting point. They noted that the Victorian criminal charge book had actually been updated after their decisions in Paul and Sekhol to include warnings very similar to the ones they were now saying were required. The causal link point and the little weight warning. Churchill's trial happened before that specific charge book update, so Judge O'Connell hadn't given those now recommended directions.
So essentially, the VSCA applied its own recent precedents, which mandated these specific warnings, found the trial judge hadn't given them because they weren't necessarily seen as mandatory at the time or weren't yet in the charge book, and concluded this was a fatal error.
That's a fair summary. Based on their interpretation of the law, heavily influenced by their own recent case law requiring these specific warnings, they found the trial instructions were insufficient.
And the result at the Court of Appeal?
They handed down their judgment on June 28, 2024. Appeal allowed, convictions quashed, and they ordered a retrial.
So a huge win for the defense at that stage, back to square one.
A very significant turnaround, yes. All based on the perceived flaw in the jury directions about that one piece of evidence, the delayed distress.
But as we know, that wasn't the final chapter. The prosecution decided to fight the Court of Appeal's decision.
Correct. The Director of Public Prosecutions for Victoria, representing the King, wasn't satisfied with the retrial order. They sought, and were granted, special leave to appeal to the High Court of Australia.
Special leave. That means the High Court thought this was a really important legal issue, right?
Exactly. It signals the case involves a significant question of law, often one where different appeal courts might have conflicting views, or where the interpretation of legislation needs clarification at the highest level. Leave was granted relatively quickly, November 7th, 2024, and the hearing itself was expedited, showing the urgency and importance the High Court attached to it.
And who are the legal big guns brought in for the High Court showdown? Any changes?
Yes, particularly on the defense side. For the king, the appellant, it was Brendan F. Cassane, Casey King's counsel, a senior prosecutor leading Stephanie Clancy, who had run the case below, instructed by the OPP.
Okay.
But for Ryan Churchill, the respondent, the team was now led by Brett W. Walker, SC senior counsel, one of the country's most respected and sought-after barristers, appearing with Arshan SC and H.L. Canham, who had handled the case previously, instructed again by Doug plus George. Bringing in someone like Brett Walker SC really underscored the high stakes and the complex legal principles involved.
Definitely signals the significance. So what was the exact legal question the High Court agreed to answer? They usually frame it very precisely.
They did. The core issue was this fundamental conflict between the modern Victorian statutes, the Evidence Act, and the Jury Directions Act, and those warnings the VSCA said were mandatory, which seemed rooted in older common law ideas. The High Court basically asked, in a sexual offense trial under these acts, if the prosecution relies on the complainant's distress when making a complaint as evidence supporting her story, are there substantial and compelling reasons? That's key phrasing from the Jury Directions Act, requiring the judge to warn the jury they must find a causal link, and that the evidence generally carries little weight.
Okay, so it directly tests whether those specific warnings the VSCA insisted on are actually required under the current statutes.
Precisely. It put the VSCA's mandatory warning rule squarely under the High Court's microscope, measured against the language and structure of the Victorian legislation.
Right. Let's dive into the arguments. What did the king, the appellant, argue to the High Court? Why should the conviction be reinstated?
Their argument, led by Mr. Cassane Casey, was fundamentally about statutory supremacy. They argued that the Evidence Act and the Jury Directions Act, the JDA, create a complete, self-contained scheme for evidence and jury directions in Victoria. And this modern statutory scheme, they said, overrides any older judge-made common law rules that might have required specific warnings about distress evidence.
So Parliament's laws trump the old case law.
That was the core message. They argued, look, distress evidence like this is relevant under Section 55 of the Evidence Act. It potentially makes the alleged assault or the complainant's credibility more likely. And if it's relevant, Section 56 says it's admissible unless some other rule excludes it. Simple as that. Then, a huge part of their argument focused on the jury's job. They stressed that deciding the weight or value of evidence once it's admitted is the classic fundamental role of the jury. It's their decision, telling them that a whole category of evidence, like distress, generally carries little weight. That's the judge improperly stepping into the jury box and telling them how to do their job.
Interfering with the jury's assessment.
Exactly. They cited cases confirming the jury as the constitutional fact finder, the assessor of weight. They argued the JDA reflects this. It sets out how directions work. Judges give general directions, like on circumstantial evidence. Specific warnings about particular types of evidence are only given if counsel requests them under Section 14, or if there's a substantial and compelling reason under Section 16.
And they argued distress evidence doesn't automatically trigger that.
Right. They pointed to Section 31 of the JDA, which lists specific types of evidence that might be unreliable and might need warnings like hearsay or evidence from children or identification evidence. But crucially, pretrial distress evidence as a category isn't on that list. So their conclusion was, just because evidence involves distress doesn't automatically mean there's a substantial and compelling reason for a special warning about its weight or needing a specific causal link finding. The statute doesn't single it out that way.
So this directly attacked the foundation of the VSCA's ruling, which relied on those older common law cases.
Absolutely frontally. The Crown argued that those cases, Flannery and the Victorian ones following it, like Paul, Suckle, namely, that mandated warnings about causal links and little weight were simply incompatible with the statutory scheme. They argued these rules were effectively abolished by the legislation, particularly Section 34 of the JDA, which limits mandatory unreliability warnings to what's specified in the Act. The language reported later from the High Court judgment captured this vividly. These common law rules were interred by statute, their ghosts ought to be banished.
Strong language. Did they rely on any High Court precedent?
Yes. They pointed to earlier High Court cases like Papakosmos, which said complaint evidence can be used as proof of the facts asserted in it, and IMM and Bauer, which suggested distress accompanying a complaint, can be relevant. That freshness isn't just about time, and that juries are capable of assessing these things. They argue the VSCA hadn't given enough weight to these higher court rulings, and ultimately they said Judge O'Connell's original directions on circumstantial evidence were perfectly adequate.
Okay, a comprehensive argument for sticking to the statute and trusting the jury. What was the counterattack from Ryan Churchill's team, led by Brett Walker, KC? Why did they say the VSCA was right to order a retrial?
Their argument was more nuanced, focusing on the specific facts of this case. They didn't necessarily argue that all distress evidence always needs these warnings. Instead, they argued that in this specific case, the circumstances did amount to substantial and compelling reasons under Section 16 of the JDA, making the warnings about causal link and weight necessary here.
So they were arguing this case met the statutory threshold for specific warnings, even if others might not.
Exactly. And what were those reasons? Primarily, they hammered home the weakness of the alleged causal link. They pointed again to the one-year delay, and crucially, the sheer number of other intense stressors surrounding the complainant at the children's court, the running away, the substance use, police, child protection, the court setting itself, plus her underlying mental health context and autism, which she herself linked to her meltdowns. They argued, given all that, how could a jury rationally conclude the meltdown was solely or even primarily caused by the alleged 2005 abuse? It was just too speculative, too many other potential causes. They cited sources detailing these stressors and the difficulty of isolating the abuse as the definite cause. They also raised broader concerns about demeanor evidence generally. They argued interpreting emotional states like distress is inherently tricky, it's imprecise, variable, and juries might easily misjudge it or give it too much weight just because it's emotional and sympathetic. They cited material about the difficulties in reading demeanor accurately.
This sounds a bit like the concerns underlying the old common law rules the VSCA relied on.
It does echo some of those concerns, yes, but framed in a more modern context. They weren't necessarily reviving outdated stereotypes, but arguing that even with modern understandings of trauma, interpreting its delayed and complex manifestations is fraught with difficulty and risk of error, justifying judicial guidance. Another key argument was about bootstrap reasoning. They suggested the prosecution was asking the jury to reason in a circle. Believe the complaint, he raped me, because she was distressed, and believe the distress was caused by the rape because she said he raped me. They argue this is impermissible, using the content of the complaint to validate the distress, which is then used to validate the complaint itself, using one to prove the other in a loop. Precisely. They also slagged potential issues with the quality of the evidence about the meltdown itself, relying on the mother's memory from 16 years prior, and the complainant's own initial difficulty recalling specifics. They argued all these factors together, weak link, inherent difficulty of demeanor evidence, risk of bootstrap reasoning, evidence quality, cumulatively created those substantial and compelling reasons under the JDA requiring the judge to give specific cautions in this trial.
So they weren't necessarily defending the old common law rule as universally applicable, but arguing that this case, on its unique facts, fit the exception within the modern statute that did require those specific warnings.
That's the essence of it. They argued the trial judge failed to give directions that were necessary on these specific facts, even under the JDA framework, and the VSCA was right to identify that failure. The High Court had to decide which side had correctly interpreted the statutes and applied them to these very complex facts.
Okay, the stage was set for a definitive ruling. What did the High Court decide after hearing these powerful arguments?
The High Court handed down a unanimous judgment on April 2nd, 2025. Unanimous is always significant.
And the outcome, the bottom line.
The bottom line, the King's appeal was allowed. The Victorian Court of Appeal's decision ordering a retrial was thrown out. Ryan Churchill's original appeal to the VSCA was dismissed. And the ultimate effect, his convictions, decided by the jury back in 2022, were reinstated.
Wow. A complete reversal of the Court of Appeal. What was the core reasoning from the High Court justices?
The absolute central point was that the Victorian Court of Appeal was wrong. They were wrong to find that those specific directions requiring the jury to find a causal link and warning that distress evidence generally carries little weight were legally required.
So back to that statute versus common law conflict.
The High Court landed firmly on the side of the statute. They explicitly endorsed the Crown's argument that the old common law rules mandating these specific warnings from Flannery and the Paulsacol-Nimley line are fundamentally inconsistent with the Modern Evidence Act and Jury Directions Act in Victoria.
And they use that strong language.
Yes, the judgment summary uses that striking phrasing. These common law rules are interred by statute and their ghosts ought to be banished. A very clear message. The legislation passed by Parliament is the law now, and judges shouldn't be trying to keep alive requirements based on superseded common law doctrines. They confirmed again. Distress evidence accompanying a complaint is admissible as relevant circumstantial evidence under Section 55 unless some specific rule excludes it.
Then once it's in, who decides its value?
The jury. The High Court was crystal clear on this. Once the evidence is admitted, quoting from their summary, it is for the jury to determine whether to accept the evidence and the weight to be given to the evidence, in the exercise of its collective wisdom informed by the ordinary knowledge and experience of its members. This is a powerful reaffirmation of the jury's role as the fact finder and weigher of evidence, pushing back hard against judges telling juries how much weight a category of evidence generally deserves. They reiterated the JDA structure. General directions are standard. Specific directions are exceptions, only if requested under S14 or if there are substantial and compelling reasons under S16. And crucially, the High Court held that the mere fact that evidence relates to pretrial distress is not by itself a substantial and compelling reason, demanding those specific warnings about causal links or weight.
So that mandatory rule the VSCA had established, gone.
Gone. Directly rejected. The High Court found that the trial judge, Judge O'Connell, his actual directions covering circumstantial evidence outlining the competing arguments about the distress, warning about drawing reasonable inferences were sufficient in this case to guide the jury. The extra warnings the VSCA wanted were simply not required by law. They also tackled the idea of distress being unreliable evidence. They noted Section 31 of the JDA lists kinds of potentially unreliable evidence needing potential warnings, but distress isn't on that list. So, perpetuating warnings based on old common law ideas about distress being inherently unreliable or having little weight, that's inconsistent with the statute.
But what about the defense's point that in this case the link seemed weak, there were other causes? Didn't that make it substantial and compelling?
The High Court's ruling essentially says, yes, those factors that delay the other stressors are absolutely relevant, but they are relevant to the weight the jury decides to give the evidence. It's precisely the jury's job to consider those competing explanations, to weigh the possibility that the distress had other causes, using the general directions on how to assess circumstantial evidence. The presence of those complexities doesn't automatically trigger a need for a mandatory, specific judicial warning based on defunct common law rules. The High Court put faith back in the jury's ability to handle that complexity.
So a really fundamental reset from the High Court. They're saying the Victorian Court of Appeal overstepped by creating mandatory warnings based on old ideas, and Parliament, through the new acts, intended to trust the jury much more with this kind of difficult evidence.
That is absolutely the core message. It clarifies the law significantly, emphasizing the statutory framework and the jury's central role.
So what were the immediate consequences for the people involved, and what are the wider ripples from this decision?
Well, for Ryan Churchill, the immediate impact was clear. His conviction stood. No retrial. For the complainant, Isla Murphy, the source material suggests that this final decision brought a sense of legal closure after a very long and undoubtedly difficult process. The broader implications are huge, though. This decision fundamentally changes how distress evidence must be approached in Victorian sexual offense trials, and it will almost certainly influence courts in other parts of Australia with similar evidence laws. It explicitly kills off that line of Victorian authority, Paul Secco, namely, that mandated the specific warnings.
It really underscores the power of legislation over judge-made law.
Definitely. It's the High Court strongly asserting that Parliament's detailed schemes in the Evidence Act and Jury Directions Act are intended to be comprehensive, and courts shouldn't be adding extra layers based on older common law ideas, especially ideas that might reflect outdated views about victims or juries.
And it really elevates the jury's role, doesn't it? Puts a lot of trust in them.
Immense trust. It reinforces their constitutional function and their perceived competence to weigh all the admissible evidence. The High Court is essentially saying, guide the jury with the general principles, let the lawyers argue the competing interpretations based on the specific evidence, and then trust the jury's collective wisdom to sort it out, rather than giving them prescriptive warnings about certain categories of evidence.
But, and this feels important, while the High Court clarified the legal rules for directing juries, it doesn't magically solve the underlying human difficulty of interpreting trauma, does it?
Not at all. That's the enduring challenge. The law now has clearer instructions for judges, but the core task remains incredibly difficult. Evidence of trauma is complex, it is subjective, often delayed, often tangled up with other life events. The justice system still has to grapple with how to fairly assess that within its rules. The High Court's ruling basically places that difficult assessment firmly in the hands of the jury, trusting them to navigate the nuances.
So, to recap, The King v. Ryan Churchill went from these disturbing allegations to a jury conviction, then an appeal court overturning it because of directions based on older common law about distress, and finally, the High Court bringing it full circle, reinstating the conviction by prioritizing the modern statutes and reaffirming faith in the jury's ability to weigh complex evidence without those specific mandated warnings.
A real legal roller coaster, but one that has significantly clarified an important area of evidence law concerning trauma.
It certainly has. And it leaves us, and you listening, with a final thought, doesn't it? The High Court has clarified the legal directions. But the deeper human question persists. How do we, as jurors, as a society, truly grapple with the complexities of trauma? How do we interpret and weigh its often delayed, messy, and deeply personal expressions when the legal system asks us to make profound judgments based upon it?
A question the justice system and all of us continue to face.
Thank you for joining us on this deep dive. It's been a fascinating look at the intersection of law, trauma, and the ongoing quest for justice.